Hello and welcome to Calm the Pharm podcast, where pharmacy business meets legal wisdom, minus the headache. In each episode, we share practical legal tips and real-life examples to help you run your pharmacy with confidence. I'm your host, Sarah Stoddart. Thanks very much for joining us. Today on the podcast, I'm talking about the Pharmacy Industry Award, which is an award which governs most of the people that work in the pharmacy industry, from pharmacists, pharmacy assistants, dispense techs, etc. Most of our listeners will be familiar with the award, and I thought it might be useful to, over the next couple of weeks, chat about some of the key provisions in the award. Today, I'm starting with Clause 13A, which is the employee's right to disconnect. Now, this is a law which is relatively new in Australia, but it is an important one for employers to be aware of. An employee can exercise their right to disconnect, which means that outside of hours, unless it is unreasonable to do so, an employee may refuse to monitor, read, or respond to contact or attempted contact from their employer or a third party if that third party is trying to contact them about work. Now, for most of us, we understand what the right to disconnect means in terms of if the employer tries to call you or send you an email, there is no obligation on the employee to actually respond or read or monitor that contact. However, where the lines get blurred is where there are, for example, group chats on Facebook Messenger or WhatsApp or similar, where there is work discussions. Now, whilst the purpose of those group chats might be for general banter and discussion, it is important for employers to keep in mind that if they are posting something in there relating to work, there is no obligation on the employee to monitor, read, or respond to that, and the employee can actually refuse to do so. So if you are popping something in the group chat relating to a change of an employee's hours or asking for change of shifts, and that's happening outside of the employee's working hours, you can't expect the employee to engage with that content. Now, I did mention that the employee's refusal doesn't apply where it is unreasonable, and the Fair Work Act in Section 333M lists the matters that must be taken into account in determining whether the employee's refusal is in fact unreasonable. Those matters that can be taken into account in determining the reasonableness of the refusal include the reason for the contact or the attempted contact, how the contact or attempted contact is made, and the level of disruption that causes the employee. So obviously, contacting them via every possible means known to man is going to be very disruptive, as opposed to perhaps mentioning something to them when they're in store as a customer, or perhaps sending something in the chat group when they're already engaging and responding. That would be little disruption because they're already there, already engaging. Also relevant is the extent to which the employee is compensated to remain available during the hours in which you're contacting them, or for working any additional hours outside their ordinary hours. So if you're offering additional pay or they are on call and there is compensation for that, then obviously the entitlement to contact them and their ability to refuse completely changes. Also relevant is the nature of the employee's role and the employee's level of responsibility, as well as their personal circumstances. So if, for example, you're aware of the employee having caring responsibilities, parental responsibilities, then that obviously changes things in terms of their refusal to be contacted outside of their hours and their right to disconnect. In terms of their role and level of responsibility, if they are a casual cash and wrap person that works on the weekend or after school, that's a lower level of responsibility than, say, for example, one of the owners that is also employed to work in the business as an employee. For an owner that is also an employee, they have a higher level of responsibility, and therefore it may be unreasonable for them to refuse to be contacted outside of hours, particularly if the contact is about something that is quite important and that requires a response. There is also provision in the Act about how disputes around the employee's refusal is going to be dealt with. I'm not going to go into that in this podcast, but it is important to know that there is a process set out for managing those disputes. Two other key factors to keep in mind is that this is now law as of the 26th of August 2025. So the right to disconnect applies to all employees regardless of the size of their business from that date. Therefore, the employees that you have in your business do have this right. And as an employer and under the Pharmacy Industry Award, you must not directly or indirectly prevent them from exercising their right to disconnect under the Act. The other thing worth mentioning before we wrap up today's episode of Calm the Pharm podcast is that the right to disconnect, be it through the Fair Work Act or under the Pharmacy Industry Award, does not actually prevent you from contacting or attempting to contact your employee outside of their working hours. If, for example, you're notifying them of an emergency roster change, for example, the right to disconnect is more about the employee's ability to refuse to monitor, read, or respond to that contact. So you can contact them, you can't expect them to monitor, read, or respond. So there is an important differentiation to keep in mind there. But overall, the employee's right to disconnect is now law, something we need to be aware of. And if you are contacting your employees outside of hours, it's important to think about whether you should be doing that and also how their rights are at play and whether their refusal to respond is reasonable. And if they are not responding, whether that is unreasonable. Also important to keep in mind is if you are contacting employees outside of hours, an employee could exercise that right to any time, and you don't want to then have a dispute about that. So think about the contact you're having with your employees, whether it's necessary and whether anything needs to change. That's all for today. I'll be back next week. Thanks for listening.